Welcome, friends. Welcome to the masterclass on Insolvency and Bankruptcy Code 2016. Friends, the intention is that IBC has gone through amendments many times, and honestly, all IPs has worked on various assignments very much earlier, but at present, something we need, or you can say refreshment of the knowledge, and we intended that we should have that with the decided case laws of NCLT, NCLAT, Supreme Court, and relevant disciplinary order. And as you know, friends, there is a proposed amendment in the code. So wherever applicable, we are going to discuss that also. I will reduce, I'll be very short because we have only 1 hour, which may extend to 1.5 hours if required. And we have lot many things to discuss. So shortly, thank you, Mr. Rajan Agarwal. Thanks for this.
Madam, I seek your apologies. I wouldn't be able to extend the time today, because I am traveling out of town tomorrow morning for 3 days, so I need to cover up some things in my office. So my request would be that.
So today's topic is relevant provisions, case laws, and disciplinary orders. Session 1, application by financial creditors. Presenter is Kunal Sharma. And our panelist is Devang Thakkar also. So to formally introduce Mr. Rajan Agarwal is a Bachelor of Commerce, Chartered Accountant, Advocate, and Registered IP with over 3 decades of professional experience in account, taxation, corporate advisory, corporate finance. Currently practicing as an IP and advocate specialized in insolvency resolution, restructuring, NPA management, and advisory under IBC. He has successfully handled CRP assignment as IRP, RP, achieving 100% recovery for all stakeholders. Mr. Rajan has been profiled as one of the 50 NM personalities by NM College of Commerce. You are from NM? I am also ex-NM.
I am ex-NM, ma'am. 1984 batch.
1984? I am 85.
Okay. So I am senior to you, ma'am.
Yeah. He served as a visiting faculty at leading law college and has been regular speaker at seminar professional and forum on IBC, project finance, and insolvency law. Welcome, Mr. Rajan. Thanks for your time. Mr. Devang Thakkar is a professional with 3 decades of experience in area of finance, secretarial compliance, and corporate legal. He holds bachelor degree in science, diploma in system management, and a master degree in financial management from NMIMS. He is an associate member of ICSI and is also empaneled as independent director. And he is also IP, and his professional experience spans to various industries. I am reducing the introduction so that we can start the session. With this, I'll just request Kunal to start his presentation. Over to Kunal.
Thank you so much, ma'am. Very good evening to everyone. So we will move directly towards the case laws that from the various tribunals and Supreme Court and NCLTs. So
the friends, Section 7, as everyone knows, it's an application by financial creditors and for IBC. We are not covering provisions because it's by-hearted by everyone very much time. And what we have done is we have taken the decided case laws only for that Section 7 to, have a more in-depth knowledge on the subject. Just bear with us. Okay. Yeah, Kunal, start.
Really sorry, ma'am, for the inconveniences.
Yeah, start sharing your screen.
Yes, ma'am. Am I audible and visible?
Yeah.
Thank you, ma'am. So the first case law that we'll be discussing is, we'll be discussing first the Section 7 of IBC, that is the initiation of corporate insolvency and resolution by process by the financial creditor. We'll be moving ahead with the definition, and then we'll freshly start with the case laws under IBC. So the first case law that we'll be discussing is State Bank of India and others versus India Power Corporation Limited. The judgment was passed by Supreme Court on 14th of February 2025. The facts of the case are as follows. SBI filed an application under Section 7 of IBC before NCLT Hyderabad in February 2020 to initiate CIRP against IPCL. IPCL filed its counter affidavit, and in response, SBI had delayed in filing rejoinder affidavit due to pending money suits instituted by IPCL. Thereafter, SBI filed its interim application seeking condonation of delay in filing rejoinder affidavit. Here, the NCLT Hyderabad condoned the delay but directed that any factual assertions
Last
in the rejoinder would not be
Mr. Rajan, you need to mute yourself.
Yes.
Yeah.
Continuing with the NCLT's order, that NCLT Hyderabad condoned the delay but directed that any factual assertions in the rejoinder would not be considered while deciding the Section 7 application. This order was challenged before the NCLT, where appeal was dismissed, affirming the NCLT's order. Then, as SBI approached Supreme Court by way of statutory appeal, and the major issue which was dealt before the Supreme Court was whether the NCLT and NCLT were correct in directing that factual assertions in rejoinder should not be considered while deciding the Section 7 application and condoning the delay after the IBC under the IBC. The decision of Supreme Court noted that Rule 42 of NCLT rules has been ignored and reaffirmed its principle laid down in its own judgment, namely Dena Bank versus Sri Shiv Kumar Reddy, and Supreme Court allowed the appeal, set aside the impugned order by the NCLT, and directed that the matter be remanded to the NCLT for fresh consideration of the Section 7 application. This was the judgment of the case. Kindly put your comments on this case.
Yeah, you can go ahead.
The issue before the court here is essentially whether any factual assertion can be made in a rejoinder, right? So the fact of the matter is that whenever you are filing a rejoinder, you are not permitted to bring new facts on the scene, because if you bring new facts on the table, then again the respondent will ask for a reply to be given to the new facts that have been brought in the rejoinder. So generally the courts they scoff that you are not supposed to come out with new facts which were not stated in your main application. And to that extent, probably the NCLT has given a correct view. But the fact of the matter is that ultimately the Supreme Court says that you can file additional documents, right? So it is not saying that you cannot. So the issue is not whether you can file additional documents or not. So pertaining to the case, whatever new documents you can file, but I am of the opinion that at a later stage in the case, it is not permitted that you come out with new facts, because then they need to be again rebutted, and if this goes on, then the pleadings will never be completed. So generally, coming out with new facts is not permitted. Filing of new documents which are pertaining to the facts which are there before the court, pertaining to the law that is there before the court, I believe that is quite okay, and that the Supreme Court has also allowed. This is my opinion in the matter, sir.
Thank you. Yeah, next, Kunal.
Okay, ma'am. So moving to our next case law, that is Rakesh Arora and others versus Acute Daily Media Private Limited and others. This order was passed by NCLT on 8th of March 2025. In this case, the financial creditor Acute Daily Media Private Limited and others filed an application under Section 7 before the NCLT to initiate CIRP against Sharp Eye Advertising Private Limited. The NCLT accepted the application and initiated CIRP, but there was an operation and mismanagement case pending before this application. The majority shareholders, Rockman, namely Rockman Advertising and Marketing India, alleged that CIRP was initiated fraudulently to derail the company law proceedings. For this, they filed an interim application under Section 65 of IBC before the NCLT. The NCLT held that CIRP was initiated fraudulently and recalled it, also ordered to restore management to the promoters and suspended directors. No penalty was imposed and no notice was issued to promoters at this stage. The majority shareholders made an appeal before the NCLT where they sought immediate penalty on financial creditors and promoters under Section 65 of IBC. The major issue raised before the appellate tribunal was whether the promoter of a corporate debtor can be penalized for alleged collusion even though they did not file the Section 7 application. The appeal was dismissed by the appellate authority and held that Section 65 penalty can be imposed only on the person who initiates CIRP. The promoters cannot be penalized under Section 65 of IBC.
Okay, so I'll proceed with my comments.
Yeah,
Sure,
please.
sir.
Okay, so basically Section 65 pertains to fraudulent initiation of CIRP proceedings. So the promoters of a corporate debtor are not permitted to initiate corporate insolvency process, right? So if that is the case, if they cannot initiate CIRP, then there is no question of imposition of any penalty on the promoters under section 65 of the code. And that is precisely why the penalty has been levied only, or rather, show cause notice has been issued only to the financial creditor which initiated the CIRP proceedings and not the promoters. And one more point which comes to my mind, in this particular case, the NCLT reviewed its own order, and it reviewed its own order and it passed a new order in the IA file stating that they are annulling the CIRP proceedings that are started, and the issue that comes here is whether NCLT can review its own orders. I leave it for everybody to think on this. As of now, I am not dwelling further into this. So one more point that comes to my mind is whether NCLT is empowered to review its own orders. Yes, sir. Further.
What is your view, Mr. Rajan?
So ideally, NCLT may not be permitted to review its own orders. Basically, once you have passed an order, then it becomes a subject matter of appeal only at a higher court.
Yeah, right.
See,
Even I hold that view.
So if you start reviewing an own order, then NCLT will keep on reviewing its own order, and basically there will be, I would say, chaos in the whole thing.
Moving to our next case law, that is Manish Ramakant Sapte versus Export Import Bank of India and others. This order was passed by NCLT on 24th of April 2025. The facts of the case are as follows. The Export Import Bank of India, along with other respondents, extended a term loan of $45 million to Suezra Holdings BV Netherlands under the corporate guarantee of Manish Pharmaceuticals Limited in September 2007. The loan was classified as an NPA in 2011. Owing to the persistent non-repayments, the financial creditor thereafter initiated proceedings before the Queen's Bench UK, which culminated in a decree against both the parties for recovery of outstanding dues. The financial creditor filed an application under Section 7 of IBC on 30th of August 2019. The application was initially dismissed by the NCLT on limitation grounds, but the dismissal was set aside by NCLT in May 2023 and was later affirmed by the Supreme Court. Then later, NCLT Mumbai bench admitted the Section 7 application and initiated the CIRP. The suspended directors challenged the admission before the NCLT and deposited an amount of 369.11 crores, claiming the full satisfaction of the dues. The issues raised before the appellate authority was whether deposit of substantial amounts by the corporate guarantor after admission can prevent or nullify the initiation of CIRP. Here, the appellate tribunal held that deposit of money by the corporate debtor or guarantor does not nullify or reverse the CIRP after admission. Here, the appellant was granted liberty to submit a settlement proposal before the COC and seek withdrawal of CIRP under Section 12A, read with Regulation 30A, subject to the 90% approval. In case of failure of settlement, the appellant may seek refund of the deposited amount with interest.
Okay. So basically, once this corporate debtor has been admitted to CIRP, there is no right to the promoters, suspended directors, that they can approach the NCLT for nullifying or reverse the CIRP admission order just because they are willing to pay the full amount of the CIRP. So this is not a matter of right. And once it is admitted, then you have to follow the procedure of 12A. Without that, it is not possible, Section 12A, and without that, it is not possible to get the corporate debtor out of CIRP. If you were to see the new amendments that have been proposed, right? So once a Section 7 application is admitted, it can be withdrawn only with 90% approval of the Committee of Creditors. Withdrawal is now prohibited before the COC is constituted and after the first invitation for a resolution plan is issued, right? So they are making rules for withdrawal under Section 12A quite stringent. Now, one thing that comes to my mind is what about the time period from the order, the final after arguments, the matter is reserved for orders, And before the order is pronounced, if the promoter wants to pay, then the situation is that there is no case for the petitioner not to accept that amount, and the petitioner shall have to accept the amount, and the corporate debtor shall have to come out of CIRP. There are decided cases of NCLAT that if before the corporate debtor is admitted to CIRP after reserve for orders, during that time, window is available to the promoter to pay the full amount and get the corporate debtor out of CIRP.
Okay, sir. Now moving to our next case law, that is IL and FS Financial Services Limited versus Adhunik Meghalaya Steels Private Limited. This judgment was passed by Supreme Court on 29th of July 2025. The facts of the case are as follows. IL and FS Financial Services Limited gave a term loan of 30 crore to the respondents secured by a pledge of 8,10,804 shares of Adhunik Metallics Limited. The respondent's account was declared a non-performing asset and notices of default and recall were issued. The balance sheet of the respondent for the financial year 2018-19 was uploaded on 2021, which recorded the secured borrowing amounts as 24.41 crores. The financial creditor filed in Section 7 IBC application on 15th of January 2024 for amount of rupees 55.45 crores, claiming the application was within limitation due to acknowledgement in 2019-20 balance sheet and the exclusion of limitation period as per the Supreme Court COVID-19 orders. The NCLT Guwahati rejected the application as being time barred, observing that the balance sheet of 2019-20 did not contain any acknowledgement of debt. As the creditor's name was not specifically mentioned, the order was challenged and NCLT upheld the NCLT's decision. The appellant challenged these orders before the Supreme Court, and the major issue which was addressed before the Supreme Court was, does the entry in balance sheet of financial year 2019-20 constitute a valid acknowledgement of debt by the respondent under Section 18 of the Limitation Act 1963? The Supreme Court in its judgment held that the entry in balance sheet financial year 2019-20, when read with the context of previous year's financial statements and surrounding circumstances, constitutes a valid acknowledgement of debt under Section 18 of Limitation Act. The court reaffirmed that by virtue of Section 238A of IBC mandates the application of Limitation Act in the proceedings before the NCLT and NCLT. If the balance sheet acknowledges reducing secured borrowings over years and when accounted along with the limitation exclusion by COVID-19 orders, then it will be accounted as loan within the limitation period.
Yeah, please go on.
Yes, sir. Yes, ma'am. I have completed my case law. If there are any comments,
Mr. Rajan.
The issue in this case is whether the entries in the balance sheet, whether they constitute a valid acknowledgement of debt, right? So now it is settled law that if there is an entry on the liability side of the balance sheet, then this entry shall constitute a valid acknowledgement of debt, right? So this basically is a very settled law. Now, I give you another case law, Asset Reconstruction Company India Limited versus Vishal Jaiswal. This is a 221 case, right? So the court again, Supreme Court again here, it ruled that the entry in the balance sheet shall be taken as a valid acknowledgement of a valid debt, right? Now, basically, what happens where there is an acknowledgement of debt? When there is an acknowledgement of debt, as per Section 18 of the Limitation Act, the period of limitation is extended by 3 years. So, for example, if the corporate debtor in its balance sheet admits the liability, rather it mentions the name of the creditor in the balance sheet, then it means that now the debt, the limitation period of the debt increases by 3 years, and then the creditor has 3 more years to initiate legal proceedings to recover the debt, right? So basically what happens is, on a year-to-year basis, if the company is showing the debt in the balance sheet, then it only means that on a year-to-year basis, the debt is getting acknowledgement and the limitation period is getting extended. Now, the entry in balance sheet should not should be a non-binding note, but it should not be a non-binding note. Means there should be no note in the balance sheet that this acknowledgement is not binding. That is one thing. Secondly, mm, uh, this has to be read in consonance with the audit report of the company. Thirdly, if there is no separate line item, if there is no separate line item showing the name of the creditor, it does not negate the acknowledgement of debt if the debt is traceable and consistent with past record. So here also the Supreme Court in its order has stated that looking at past records, we say that there is an acknowledgement of that. So basically, if the entry is there, then it is in the balance sheet, it is an acknowledgement of that. Settled on.
Thank you.
Yes, sir. So, may I move to the next case law?
Yes, please.
Yeah, proceed. The moment it stop, please go ahead.
Yes, ma'am. Thank you, ma'am. Now, the next case law that we'll be discussing is Mansi Brar Fernandez versus Subhash Sharma and others. The judgment was passed by Supreme Court on 12th of September 2025. The facts of the case are as follows. The Mansi Brar Fernandez entered in an MOU with Gayatri Infra Planners Private Limited in 2016 for purchase of 4 flats for which she invested rupees 35 lakhs. This MOU had a buyback clause at the discretion of the corporate debtor, but no flats or payments were delivered and post-dated checks were dishonored. She initiated CIRP under Section 7 of IBC and the proceedings under Section 138 of NI Act, but later the CIRP was set aside by the NCLAT. Similarly, Sunita Agarwal invested rupees 25 lakhs with Antriksh Infratech Private Limited under a buyback clause of 25% annual returns, but no construction was commenced, and she also filed a Section 7 IBC application, which was admitted ex parte by NCLT, but was later set aside by the NCLT as speculative. Here, 4 appeals were heard together by the Supreme Court, 2 arising out of the NCLT orders and a cross appeals by the directors of Gayatri Infra Planners Limited, which challenged the NCLT order on the ground of non-applicability of IBC Amendment Ordinance Act 2019. The major issues which were addressed by the Supreme Court were whether the appellants Mansi Brar Fernandez and Sunita Agarwal fall within the category of speculative investors so as to disentitle them from initiating proceedings under Section 7 of IBC. The Supreme Court affirmed the NCLT's findings that the appellants Mansi Brar and Sunita Agarwal were speculative investors and not genuine home buyers, thereby disentitling them from initiating CIRP as per Section 7 of IBC.
Okay, so basically we have various judgments of Supreme Court wherein they have distinguished between the speculative investor and genuine investor. So the cases that we can cite are Pioneer Urban Land and Infra versus Union Bank of India 2019. Then there is another case, Duni Chand Rataria versus Buwalka Brothers Limited, right? So the Supreme Court generally says that purchase of a residential unit would be termed as speculative if there is no intention to take possession, or if the goal is only to earn high rate of interest, or if there is any buyback arrangement, or if there are multiple units bought rather than one single unit for residence, right? So if all these basically the circumstances are available, then the courts take a view that the investor is a speculative investor and cannot be treated as a home buyer, and therefore will not be entitled to the benefit which is receivable to a allottee as per Section 7.
So now let's move into the next case law, that is EPC Construction India Limited versus Matix Fertilizers and Chemicals Limited. The judgment was passed by Supreme Court on 28th of October 2025. The facts of the case are as follows. The appellant gave a loan under EPC contract to the respondents in 2009. Later, the Matix requested EPC to convert the outstanding contractual dues into subordinate debt. Accordingly, Matix allotted 25 crore CRPS carrying of 8% cumulative dividends, redeemable at par after 3 years, to EPC and SR projects. Subsequently, CIRP was initiated against applicants, that is EPC, by the NCLT. Then EPC sought redemption of CRPS along with accrued dividend aggregating to 310 crores. The Matrix responded stating that its liability towards the redemption and dividend stood adjusted against its own claim of 377.87 crores lodged against the EPC in the CIRP proceedings. After liquidation commencement, the liquidator sought leave under Section 33 of IBC and eventually filed a Section 7 application on 25th of April 2022 against Matix, alleging a default of 310 crores. The adjudicating authority rejected the Section 7 application, holding that the amount arising out of the CRPS was not payable and that no default was made out. The appellant challenged this order to the appellate authority. The NCLT upheld the NCLT's decision and held that Matix never declared dividend or earned profit to redeem the preferential shares. If the preferential shares allotted to the appellant could not have been redeemed, no debt became due. Later, this was challenged in the Supreme Court, and the major issue addressed by the court here was whether the NCLT and NCLAT were justified in dismissing the appellant's application under Section 7 of IBC after holding that the appellant was not a financial creditor. Here, the Supreme Court in its judgment held that a holder of cumulative redeemable preferential share is not a financial creditor, as such shares are part of company's capital, not a financial debt, and they cannot initiate CIRP as they do not fulfill the definition of financial creditor under Section 5(7) for the purpose of Section 7 of the IBC.
Okay. So again, it is settled law that preference shareholders are not the creditors of the company, leave alone financial creditor, right? So if you are not a creditor at all, there is no question of you being a financial creditor. And if you are not a financial creditor, you cannot initiate a Section 7 application, right? So the principle that unredeemed preference shares are not creditors was established in a pre-IBC case, Lalchand Surana versus Hyderabad Vanaspati Limited, which held that they could not file petition for winding up, right? So the preference shareholders under the company law are not entitled to file a winding up petition because they are not the creditors of the company, right? So same ratio applied. If you are not creditor of the company, you are not entitled to initiate a Section 7 application.
And again, Mr. Rajan, now the Companies Act 2013 shares include preference shares. That also clarify that it is a capital, own capital of the company. Share capital. So that also further is to be
that reinforces. So basically, we have always been taking preference share capital as part of the
capital
only, net worth of the company, right?
Yeah.
So basically, what happens is when the suppose a company is seeking debt and the bank has to calculate the debt equity ratio, right? So preference share capital will form part of equity. I'll tell you why. Because preference share capital has to be redeemable, right? You are not allowed to issue irredeemable preference shares. So if you have to redeem preference shares, there are only two ways in which you can redeem. One, out of the free reserves of the company, or out of a new issue of capital, right? So this only means that the capital is replaced. You redeem the existing preference shares and you ensure that some new capital is coming into being, right? So therefore, the capital
And you have to create capital redemption reserve, which will be always there. So your capital
redemption reserve
is always remain.
So that will always be there. Therefore, it has always been seen that once you have a preferential capital, it always remains in the company. That capital does not go down.
Right. Yeah. Yeah.
Okay. My only request to Kunal is if he can take up now, at least we can try to cover 3 disciplinary cases.
Now we'll move directly to the IBBI orders.
Meenakshi Cargo and Forwarders.
So the first IBBI order that we are going to discuss is of CIRP of Meenakshi Cargo and Forwarders Private Limited. This order was passed on 13th of January 2026, and here the CIRP was initiated by NCLT Chennai. After initiation of CIRP and appointment of IRP, a complaint dated 4th of August 2024 was received by IBBI, alleging that the IRP has failed to take control and custody of the assets of the corporate debtor, and the IRP's action are not in compliance with the GST laws during the CIRP. The IRP in its defense submitted that the delegation to the suspended director was limited to execute pre-existing and time-sensitive contracts to preserve the going concern status, and the existing GST registration was not surrendered due to the lack of login credentials. The disciplinary committee held that the undertaking executed by the suspended director clearly showed that he was entrusted with day-to-day management and overall operations. The IRP acted hastily and negligently, failing to exercise independent control. The CBIC circular mandates fresh GST registration within 30 days of IRP appointment. So in its order, the disciplinary committee suspended his registration for an insolvency professional for a term of 1 year, effective after 30 days of the order date.
Okay. So can I come in?
Yeah, please.
Okay. So basically, there are 2-3 issues that are there in this case. So basically, the first is the IP. By any chance, if I by mistake, if I take the name of the IP, it is not intentional. I don't want to take the name of any IP when we are discussing any matter. So kindly bear with me. But I don't want to take, but a mistake can happen. So my apologies. I am saying before and only. I will try to be more conscious about not taking the name of the IP, right? So basically, first thing is that in this particular case, the IP failed to take control and custody of the assets. Secondly, what the IP did, IP delegated control and management of the operations of the CD to the suspended director, right? So, and thirdly, there is this issue of is in this case only. So the GST matter is in some other matter. Okay.
So in this matter only, sir, the GST
Achha,
matter.
so the third matter is that non-compliance with the GST laws, right? So
Yes, sir.
Take a earlier slide, no, Kunal? Just
Yes, sir. Yes, sir.
so basically, as per there is a
there's a non-compliance of GST.
so there is a circular 134 of CBIC which says that for a company under CIRP, now the IRP is mandatorily required to take a new GST registration, right? So there is a very specific circular which says that this IRP has to take a new registration. So this IP failed to take that registration as well, right? So the IP has tried to say that it is the usual practice to give back control of the CD to the suspended management to run the business after taking undertaking from the suspended management. Then he is saying that there were basically perishable goods in the company and the corporate debtor, and that there were certain orders to be executed. And if the orders are not executed, it would have resulted in any penalties on the company, right? And he says that he had no alternative but to authorize the director of the suspended board to honor certain pending contractual commitments. And he further says that there is a clear distinction between management and operations. While the management of the CD vests with the IRP RP under Section 17, day-to-day operations may be carried out by an authorized personnel under the IRP RP's direction. The IP further said that he relies on the enclosed judgment in Mukund Chaudhary versus Subhash Kumar Kundra, where it was held by Honorable Enclad that initiation of CIRP does not release the directors of the corporate debtor from their duties, but it only suspends their powers, right? And he says that further, the transactions that were authorized by him were transparently presented before the COC in the first meeting. He has brought to the notice everything, right? And he says that the delegation was limited to authorization related to the execution of the contracts that were already underway before the commencement of CIRP, and therefore it does not amount to the delegation of management of the affairs of the CD, right? So IBBI, basically the disciplinary committee said that we were not provided with any document or evidence to establish the existence of any such prior contracts which required their execution post IRP. And the DC also mentions that the suspended board mentioned everywhere that suspended director, that he was working as chief executive officer with the authority delegated by the IP, right? The DC observes that as per the undertaking which the suspended director gave to the IP, the IRP, that the undertaking mentions that the suspended director was vested with full responsibility for overall operations of the CD, including protection of the assets of the CD and delegated control and direction of the day-to-day management of the CD to the suspended director. The DC further observes that before delegating his authority to the suspended director, it was incumbent upon the IP to seek approval of the Committee of Creditors. In none of the Committee of Creditors meeting, the IP put up this issue of delegation of his responsibility to the directors of the suspended board. Then the disciplinary committee notes that the IP acted hastily in delegating the functions to the suspended director without carrying out adequate due diligence regarding the need and necessity of such delegation, right? So further, the disciplinary committee notes that the IP has complained on account of non-cooperation from suspended director. So in a case where you are saying that the suspended director is not cooperating with you, in such a case, delegation becomes all the more appropriate. Further, the disciplinary committee notes that it is admitted by the IP that he was allowing the suspended management to file GST returns. It is noted that he failed to take new GST registration for the CD after the initiation of CIRP. The RP submitted that there were no new business operations in the corporate debtor. They were only completing the existing contracts, and therefore there was no requirement for him to obtain the new GST registration, right? So the disciplinary committee notes that it is not for the RP to decide that whether there would be new business in the corporate debtor or not, despite the fact that there is no fresh business in the corporate debtor. It was incumbent upon the RP to have taken a GST registration, right? So basically, the DC finds that there has been laxity or violations of section 23 subsection 2 of the code, that is he has to function as the IRP and comply with all laws, right? So section 23 to comply with all laws, that is violated.
Here, little connected question. If the person would have been executive director and a member of the board, so he's a whole-time director, employee who is a director of the committee, and he has been given duty as per employee whole-time director, then he can perform that duty as employee. Though he's a director, I think in that case there is no question that he delegation, because he's already given power as an employee.
So, ma'am, I would like to hold a little different view here. So, the suspended board, right? Whether an executive director or a non-executive director, everybody has to come under the superintendence and under the directions of the IRP and RP. And the whole issue is that can you delegate? See, suppose he is not an executive director. An ordinary
Then the question doesn't
the
come.
thing is, you want him to work for you, right? You should take. So basically, the whole idea is, can you execute an agreement, take an undertaking from the suspended director, and you can record in detail that now you are in control of the assets of the CD.
Yeah,
Now,
that's understandable.
uh,
The
so
case of the
whether
facts of the case I'm putting
the
that if a director is
so
employee,
whether
okay,
whether
as an employee, he has to perform his duty like other
So
employees.
whether an employee director or a non-employee director, the RP has to be in control of whatever has been happening.
Yeah.
Hmm.
Because like all employees. And
Like
but
all.
very interesting situation will happen because if the MD, managing director, is there in the company, then he is managing the day-to-day affairs of the company.
Hmm.
Now, managing director will be managing director if he is director of the company.
Yes, of course.
If that director, his power ceases.
Hmm.
So it's interesting as how he will function. So we have to get his duties done under specific understanding that I think RP has to take care.
So basically, ma'am, the distinction would be, if he is the managing director. Now, if the RP and the COC wants him to continue as managing director, assuming they want, he continues as managing director. The duties of the managing director, they will continue, but
Right.
powers
Rights will not be there.
the IRP RP steps into the shoes of the powers of the managing director.
Again, but Mr. Rajan, interesting here was the COC was not constituted. So even if COC, of course, COC is there, you discuss that way, but even if COC is not there, RP has to write that specific communication that you cease to be managing director. However, your duty as managing director following this is that is to be performed under the supervision direction of RP because board rights get replaced by RP. MD works under superintendent's direction and control of board.
So, ma'am, I would refer to section 28 here. Just give me a moment. I am just opening that section.
Yeah.
Section 28, right? So, it says that you cannot delegate until and unless you have permission from the COC. Certain actions which require approval of committee.
That COC approval we are not talking. Day to day function.
So, ma'am, in this particular case, the disciplinary committee has observed
No,
that.
I am not talking, Mr. Rajan, about this case. I am just taking the situation where there is a whole-time director, where there is a MD, how it will impact, and what RP has to create a document.
He has to create a document so that he has only to say that at the end of the day, the managing director is functioning, reporting to him rather, and he is aware of everything that is being done by him, or rather, it is being done with his permission, consent, etc.
Reporting and all
And,
that.
and the COC should be aware of everything.
Yeah. Till the time COC is not there, but still you create a document with that director.
So, ma'am, what I am trying to say is in this particular DC order, the DC order states that the IP acted hastily. He should have waited for the COC. You cannot delegate until and unless you take the COC into confidence. See, what I am trying to say.
Yeah. I got it. That has to take.
Okay.
Next.
Moving to our next case law, that is CIRP of Anush Finleys and Construction Private Limited. The order was passed on 19th of December 2025, and here the CIRP was initiated by NCLT New Delhi bench on 30th of May 2019. Here, after initiation of CIRP, a complaint was filed alleging that there was an undervaluation of corporate debtors' property and failure to appoint a third valuer as required under the law. Here, the one valuer assessed the property at approximately 98.5 crores and the other assessed it at approximately 66.4 crores. Here, the RP took his stand by stating that the valuation difference was not significant as one valuer's estimate included adjustments for an expected DDA penalty, and along with it, he stated that the COC consciously discussed the valuation issue and decided not to appoint a third valuer. The disciplinary committee, in its order, observed that the RP communicated an expected penalty of 39 crores but did not share documents showing discharge of DDA proceedings. And the DDA had not filed its claim amounting to rupees 39 crores approximately as calculated by the resolution professional, and therefore it cannot be counted under claims. So in its order, the disciplinary committee held that the DDA has not filed its claim amounting to 39 crores, so it won't be calculated, and a penalty of 2 lakh rupees was imposed on him. His authorization of assignment was directed not to be renewed for 3 months or till completion of the investigation, whichever is earlier.
Yeah, Mr. Rajan, anything? Here,
Sorry,
actually,
sorry, I wasn't.
yeah.
So basically, the issues that are raised by the disciplinary committee here are less sale of property of the CD at an undervalued price, failure to appoint a third valuer, and also there is the charge of non-cooperation with the investigative authority. Only because the initial notices that were issued to the IP, they went unreplied, right? So these are the issues that are there, right? So the um, IP has said that in his defense, he says that the COC has taken average of the two values to arrive at the liquidation value of the corporate debtor, and therefore there is no violation of regulation 35(1)(b), which requires that if there is a difference of valuation between the two valuers, then a third valuer has to be appointed, right? And he says that he submitted the valuation reports, and the valuation reports were deliberated upon in detail in a COC meeting, and wherein it was concluded that there was no requirement to conduct a third valuation, right? And so he also stated that one of the valuers, he has taken the value as zero only because the valuer has taken into consideration the liability towards DDA, which went to the extent of 39 crores of rupees. Right now, what happens is, how did this liability of 39 crores come to the notice of the RP, right? So what has happened is the RP has referred to a valuation report which has been taken by the financial creditor earlier prior to CIRP, in which valuation report there was mention of this liability of 39 crores of rupees, right? So basically, you are taking into consideration a report which was finalized before the start of the CIRP, right? And he further said, basically, in terms of non-replying, he said that he had inadvertently missed the earlier emails of the investigative authority. Two emails he missed, right? This justification of that, trying to justify that I inadvertently missed your emails. He says the board has taken a view that this cannot be condoned because the mails have come on your registered email ID, right? So there was a charge on this IP, which has been noted by the DC disciplinary committee, that allegation is that the property is worth 200 crores and its liquidation is value is 72 crores, and there's a significant difference between the valuation taken, and there is an attempt by the RP to sell the property at a lower value, right? So all these issues have come up in this. Now going further, right? This is a quite a long drawn order by the disciplinary committee, wherein huge amount of facts are taken into consideration, and basically the disciplinary committee has come to a conclusion that further facts are required to conclude this matter, and therefore the order which my colleague Kulal has read, that subject to further investigation into the matter, his license should not be renewed. AFA should not be renewed.
Kunal,
Yes, sir. Yes, ma'am. So, moving to our next case law, that was from liquidation of Gadari Lal Sugar and Allied Industries. The date of the order is 11th of December 2025. Here, the liquidation was initiated by NCLT Indore bench. The allegations were made that an e-auction which was conducted on November 2022, but all bidders were declared ineligible and the auction failed. Subsequently, a private sale process was initiated, and after negotiations, Radheshyam Dairy emerged as a successful bidder at 15.91 crore, exceeding the liquidation value. A complaint was filed before the IBBI alleging lack of transparency in auction and procedural irregularities in SEC meetings. The liquidator, in his defense, stated that the sale ultimately resulted in value maximization and no stakeholders suffered losses. The disciplinary committee held that the liquidator cannot introduce new eligibility criteria and not mentioned in the auction documents. And also, the SEC advice does not override statutory requirements. In its order, the disciplinary committee held the liquidator's actions were held arbitrary and non-transparent, and the DC, in exercise of power conferred in Section 220 of the Code, read with Regulation 13 of IBBI, Regulation 2017, hereby suspended the registration of the liquidator for a period of 6 months.
yeah.
Okay. So basically, in this particular case, the first defense which was taken by the IP was that this complaint is barred by limitation, because as per Regulation 3 of the IBBI grievance and complaint handling procedure, it mandates that the complaint has to be filed within 45 days of the occurrence of the cause of action. And he has taken this view that since it has been filed after 399 days, this complaint cannot be looked into, barred by the limitation, right? Now, the DC has taken a view that further, the IP had stated that this is the second complaint which has been filed, and earlier there was one complaint which was filed by the same complainant. So the DC has taken a view that in the first complaint, the defense taken by the RP was that the matter is sub judice before the adjudicating authority, and therefore it cannot be proceeded ahead. Right now, the DC says that we have orders from the adjudicating authority, we have orders from the NCLAT, and we have fresh material which is emanating from these two orders. And apart from that, the default by the RP is of a continuing nature. And if it is so, then we do not consider or we strike down the defense of the RP that it is barred by limitation, right? So this defense was not considered by the disciplinary committee. So let me bring to your notice the amendment which has happened to Regulation 3 of the IBBI grievance and complaint handling procedure, right? So this was amended on 28 January 2025, right? Now, what has happened is the period of 45 days that has been replaced with what? Now, the new period is 30 days from the date of closure of all proceedings related to the process under the code before the adjudicating authority, appellate authority, High Court, or the Supreme Court, as the case may be. Right now, what happens is that now, suppose a CIRP is going on, in that there are going to, so basically the resolution plan approval order is challenged before NCLAT, then it goes to the Supreme Court, right? Now what happens is it takes quite a few, say 3, 4, 5 years for the matter to be settled. Meeting mein bolo. Apart from that, what is happening is that there are applications we under PUFE which generally is not the priority of the bench, right? After the CIRP is over, it takes over 3 to 4 years, 5 years to complete that process, right? Now, as per this new regulation, complaint can be filed till the time each and every pending litigation in the said CIRP is not completed at all levels, including the High Court. That means you can be sure that anyone who has a grievance against you can file a complaint against you till the time all litigation is not complete, which may even take 10 years. God.
Right.
So
Yeah.
very, very scary situation, right?
Yeah.
Hmm.
Yeah, Kunal.
We should actually, as IPs, we should resist such kind of amendments. You cannot hold my neck for such a long period. You cannot hold me accountable for such a long period. At the end of the day, law of limitation, when it says we just had a case on limitation, it has to be initiated in 3 years. So something like 3 years could be a period. I can understand 45 days is too less. But as it is, let me tell you out of experience, even other, although here the disciplinary committee has given a detailed order, why speaking order, why the defense of barred by limitation was not accepted, but generally IBBI, they generally write an email stating that please proceed with providing us the details that have been asked of you. They don't want to get into any discussion with you on the matter of delay in filing the complaint. And as of now, the law is changed. Therefore, any complaint filed at any point of time, I think, is within time. Right? So I move further in this case.
Okay.
Just let. So no, I want to.
Okay,
In this
sorry.
particular case, let me see if I have any further observations. Right. So what had happened is in this particular case, that further it should be noted that at any stage, right? So this was a disclaimer at the in the process document. It should be noted that at any stage of the e-auction process, the liquidator may ask for any documents from the prospective bidders to evaluate their eligibility. The liquidator at his discretion may disqualify the prospective bidders for non-submission of requested documents. Right now, basically, some 8 entities showed interest, but only 4 of them they gave their bid applications. Right now, what has happened is the um, liquidator has declared all of them ineligible, right? So that the in this particular case, the matter went before the adjudicating authority that I observed that this is a general clause and does not in liquidator to add any new eligibility condition. It only empowers the liquidator to ask for any documents to ascertain the eligibility of builder and not to add any additional eligibility. So the adjudicating authority observed that the condition on which all the bidders were declared disqualified was not mentioned in process document, right? So this is a very serious violation that you are disqualifying bidders for conditions which are not part of the process
Yeah,
document.
auction document, right?
Mhm. Ultimately, what happened is it was decided that they go for a private sale of the CD as a going concern, and the reserve was decided at 13.44 crores, right? So this was resolved in the meetings with the stakeholders committee, right? So then at further developments, one of the creditors, Canara Bank, they got bids for 14.70 crores, and they actually approached the liquidator stating that directed the liquidator to call a meeting. Right now, what the liquidator did is he issued a 3-liner to this financial creditor Canara Bank stating that I am calling a meeting of the stakeholders committee, and what he did was he mentioned the other financial creditors or other creditors as CC to the mail which he sent to Canara Bank, right? So this is not an appropriate notice. This was held by the disciplinary committee that you cannot give notice to the other stakeholders by adding them as a CC to the mail to one of the financial creditors. Apart from that, it is noted that whatever may be the urgency, the minimum time, right, which you have to give before which a meeting can be held, right? You cannot violate that condition. So that notice period should be there. So in this particular case, the notice period was also violated. The notice was not in proper format and the notice period was also violated, right? So which basically, so the whole process can be struck down if the notice itself is defective, right? So these are the observations that are there from my side. So what happened is that in this particular case, the adjudicating authority, they passed certain strictures against the liquidator. The matter went before NCLAT. The NCLAT in its order said that considering the facts, the corporate debtor's property is now sold, and the respondent number 9, basically the complainant who had objected to the sale, he has taken back his complaint, and if the complaint is taken back, there is no reason to retain adverse remarks against the liquidator, and the remarks were ordered to be expunged by Honorable NCLAT. So these are my observations in this case.
But his registration was suspended for 6 months.
Yes, he's registered because he had because violations were there. Na? It has been noted very clearly that he has violated so many basically
Right, provisions and
provisions of the code and regulations.
Yeah, Kunal. Any
Uh,
any further order?
No. Ma'am, may I ask to be
Yeah,
excused at this stage?
I think even we have to conclude. It's 6:15. No issue. Friends, it's a very big topic, and you can see the interesting cases. We had many actually. We had to skip 3 earlier and 3 now. But thanks a lot for everything, Mr. Rajan. Thanks a lot. Even with your busy schedule, you have given time with your expert comment and so much study. Thanks a lot for your time.
One more observation, ma'am. Can you, with your kind permission?
Yeah, sure.
So I refer to the first case which we talked about limitation, right? We mentioned
right.
about limitation where entries in the balance sheet, whether they constitute an
Acknowledgement of debt or not.
So I was just very recently, I was appearing in a matter of Companies Act Section 73, subsection 4, which pertains to non-acceptance of deposit by companies, right? And I was for the respondent, which was the director of the company, right? And I had taken this view that this company. So basically, I had filed an application against the petition being a non-maintainability application. So I had mentioned various grounds on which the main petition under section 73(4) and section 76 subsection 2, which pertains to penal provisions under section 73, why they are not maintainable. So one of the issues which I raised was about the limitation, and to my good luck, the other side did not raise this point of the loan having been acknowledged in the balance sheet. So then there were other grounds on which I am granted that application. But I say that limitation was one of the points which the bench granted. I mean, the application was allowed on the point of limitation, very speaking order, clear speaking order. But what I'm trying to say is the other side did not raise this point that this debt has been acknowledged. So they could have overcome this defense of limitation had they taken up this view. right?
Right.
Acha, apart from that, the other matter where first matter where we spoke about that no new documents can be
And
filed while the matter is being discussed, right? Sub judice matter. So again, I have actually taken out that order while we were actually, during this discussion, and it says very clearly. Just let me read that. It says that additional documents can be filed at any stage, but factual assertions that were not made in the main petition, if found to have been introduced under the rejoinder, the same will not be taken into consideration. That is what the adjudicating authority has mentioned, and I believe it is a proper interpretation of law. And what the Supreme Court in that case has said that documents can be filed. I don't think Supreme Court has said that you can come out with new facts at any stage of litigation in the matter.
thank you, Mr. Rajan. Thanks for all your additional expert comment and
Well,
inputs. Thank you. Thank you for your time.
Thanks for giving me this opportunity.
you.
I highly appreciate. I have tried to give justice.
It was pleasure listening to you.
Thank you, ma'am. Thank you.
Thank you, Deva,
Thank you.
for your time.
Thank you, Rajan ji.
Thanks, everyone.
Thank you, participants. Appreciate.
Thank you.
Thank you, everyone.